we can get this to come up. So sorry, I just want to adjust my chair, Miss Anderson. Yeah. Do you know what I do? Don't worry, I'll manage. No, but Miss Anderson is going to... Oh! Gone down even further. Sorry. Oh, it's this side. Okay. This is not my normal court, as you can tell. Sorry? What am I supposed to push this down?
Yeah. Or up.
There you go, it's on the top now.
We're there. Sorry, rather undignified, but thank you.
I'm grateful, my lord. I think it's best if I just take my submissions in turn, and on each submission I'll just flag up whether I think it's really within the remit of the sort of appearance of bias argument, or whether it's something different. I think that might be the most convenient way to deal with it.
Yes.
My lord, I'm not going to spend long on the law, but I do think it's valuable just to have a quick refresh because of these differences between, how the different ideas might overlap and what approach the court has said should be taken to each. It's worth taking up Gourley because Gourley goes through a very helpful summary. It's tab 14. I don't know if actually
Yes, sorry. Tab 14 isn't any use to us because we haven't got any tabs.
202.
If you page numbers, if you could.
Page 202.
202 in the authorities bundle. I was hoping to pick it up at paragraph 7. Also, the court's welcome just to have a quick look at.
So this is a decision of the Sheriff's Court.
Yeah, what it's all about, but I'm really picking it up for the law rather than that particular case, although you'll see that later on in the bit I'm going to take you to, it does a little bit of explaining about how the law applies in that particular context. But I don't think anything turns on the particular circumstances of the case. So picking it up at tab 7, this is where the court looks at. And
Sorry, just to be tiresome, I'm not familiar with the Sheriff Appeal Court. Where does it sit in the Scottish hierarchy? Sorry, a bit unfair to ask you.
Yes, I was going to say,
It's below the Court of Session.
I'd guess that. What its relative hierarchy is to other courts, like the sort of.
Well, I suppose really what I wanted to know, I think I know the answer to this, is it, I'm sure you're not looking at it obviously from the point of view of whether it's binding on us, but it's not from a court of the same status as the Court of Appeal here.
No, and I don't actually pick it up for any of its own findings, as it were. I pick it up as a condensed summary of a law which draws out some of these sort of nuances which might be of relevance here, and it's good to see them set in a
Of course, I shouldn't even have asked you, but I was just ignorant.
Well, my lord, it's always interesting actually, because what's familiar and what isn't is always of interest.
Yes, quite.
But yes, I think it is perhaps a rather different beast we don't have an equivalent of here. So, paragraph 7, you can see it's all under the heading apparent bias, but you'll see that when we come on to look at it, the court does tackle this issue of maybe that's quite a broad heading, and you might be able to consider several different aspects of it. And I think the touchstone is in paragraph 7, Porter and McGill. You'll see that. And the question is whether the fair-minded and informed observer, having considered the facts, would conclude that there's a real possibility that the tribunal was biased. Now, what I just say about that, my lord, is that obviously fair-minded, obviously informed, and that means informed about judicial proceedings. So this is not just the situation. I think my parents once came to one of my cases and were totally shocked by everything that went on, and but it's because they weren't seeing it as a legal professional would see it. And whilst our fair-minded observer is not a legal professional as such, they are legal proceedings seen in that context. So it's not a sort of totally uninformed impression as somebody who doesn't know about legal proceedings might look at it. And the other point to make on it, judges, is that this is an intention to be objective. The reason you're picking the fair-minded observer and not what did the advocates think, what does the judge themselves think on appeal, is because what we're striving at here is an objective view, taking account of all the relevant information and saying, what would that informed person conclude? And that is important, that it's not about how the advocates come away. This isn't when one talks about justice being seen to be done, it's not that advocates have to come away feeling, that they've had a fair hearing. Imagine many often think they don't. And it's not always the case as you lose that you come away thinking that, although obviously that's more likely. It is the subjectivity that's absolutely key in my submission. So, and obviously it goes without saying, my lord, that bias is still bias. The fact that you're looking at an appearance of bias doesn't draw away from the seriousness of the allegation. So the fair-minded observer is going to know that. This is something pretty serious about a professional judge, that you say they've behaved in a biased way. And so, as I think was already canvassed, a little touched on anyway in submissions earlier, it's not just this bit seemed unfair and that bit seemed unfair. What you're saying here is that a judge was biased. And in my submission, that's something which you'll see the authorities make the point, but it's an obvious point, must be taken seriously and must be backed up with proper, cogent reasons for that, based on the circumstances. So, as in this case, you can see at paragraph 9, it's not suggested here that the individual came with partiality, that this judge had some connection. So there's some, and that's often where the bias cases come up, and it's worth clearing the decks to say that in this case there's no suggestion whatsoever. And I raise that, Judge, because of the basis for the grant of permission, that it appeared considered relevant that prior to becoming a judge, the occupation of this particular judge was being a Home Office presenting officer. I'm not going to labour the point, my lords, and my lady, but it is very important that judges should be taken as they are without having matters ascribed to them, which might seem to play under that heading, that they might be acting differently because they've got an affinity or some connection elsewhere. And it's really important, as I say, to clear the decks to say that is not this case and can never be this case. And indeed, the whole exercise of looking at what a judge did before, you can see would be beset with difficulty and liable to undermine the administration of justice if those were points that advocates could take. So in this case, you can see that the predetermination point comes up at paragraph 10. If we look at the judgment of Mr. Speetson as he then was in Persimmon Homes, this is just before the insert. It is instructive because you realise that there is perhaps a difference between premeditation, you've already decided the point, and the appearance of bias, although the two have been treated together. Predetermination is the surrender by a decision maker of its judgment by having a closed mind and failing to apply it to the task. In the case of apparent bias, the decision maker may in fact have applied its mind quite properly to the matter, but a reasonable observer would consider there was a real danger of bias on its part.
But they will overlap a lot, won't they? Because the appearance of bias might be an appearance of predetermination.
Yes, my lord, and that's why putting them in boxes isn't helpful, but there is a difference. There is a difference with saying, I didn't get a fair hearing because the judge had already decided it, and that's a procedural unfairness. That is, I have been denied a fair hearing. And this is what the judge actually did. That's what the authorities say. That's what you need to find. If you're finding premeditation, then that's what you're finding. If you're finding an appearance of premeditation...
Predetermination.
Predetermination, sorry, my lord.
Yeah.
If you find an appearance of predetermination, but it's not actually right, as it were, but it's enough to say there was an appearance of bias here to the fair observer, an informed observer, then that is a different question. And that's not a procedural unfairness question. That's not you've been denied a fair hearing, because the finding is that the hearing was fair, but it still matters that there was an appearance of bias. So there is a distinction there, my lord, which we need to keep a close eye on, because the tests are really rather different and the results are really rather different. I'm not trying to put them in boxes. I'm trying to say, be astute to the actual submission that is being made in each instance and how it fits in with what the results of that would be. And in this case, the one before the judge in Gourley, the allegation was that the judge had, in that case, in chambers, giving views, as it were, and having discussions, not in open court, but in closed courts about the case, had given an appearance of having predetermined it and showed apparent bias. Then helpfully, the court in Gourley looked at 3 Court of Appeal cases. The first one is Southwark London Borough Council, and that was about an employment tribunal. Although it's interesting to look at it, I wouldn't say that's the one I'd alight on to have greater consideration here. Then there's the case of Amjad at paragraph 14, and that had similarities to the one in front of the court in Gourley. And there you can see that the judge in that case had invited counsel into the room, etc. And the judge on that instance, after having heard evidence, gave sort of his conclusions on the evidence. You know, I've heard the claimant's evidence and believed him, and went on, etc., etc., etc. And obviously that's not this case here. So when we're talking about a closed mind here, it's not that type of case. And then Singh at paragraph 16 is the one that I would say is particularly of use, because it's set in the context of the First Tier Tribunal in an immigration context, and the appeal it was on the ground of apparent bias. And you can see that what's relied on there in the middle of paragraph 16 is that the First Tier Tribunal judge made remarks at the outset of the hearing before him, which indicated he had a closed mind and or had prejudged the appeal, and so the hearing was unfair, and that on appeal the upper tribunal judge failed to apply the correct test to the issue raised, and therefore failed to properly address the relevant points. And the insert, the citation, you can see the Court of Appeal looked at what the First Tier Tribunal judge had said in that case. And what the First Tier Tribunal judge said is, you haven't produced any documentation, this is to the appellant, and he'd expected that there would be, and he finds that that's indicative, the absence of producing this documentation by the appellant is indicative of the fact that he didn't come, in that case, to the UK in 1997 as claimed. And then the allegation is put in the next paragraph. Court of Appeal, paragraph 19, refused the appeal, and they rejected the assertions that comments were inappropriate, observing that some statements can positively assist a litigant, and I think that this morning we established that's often the case, that if a judge says, these are my concerns, this is what I consider, it helps the advocates to focus on what's really of concern to the judge, and therefore makes hearings more efficient and more effective, and hopefully more fair. So you can see in paragraph 20, the current case in Gourley was then looked at, and the arguments were advanced, paragraph 20. And it's essentially an argument of, look at these comments, and these show a predetermined view. And that's essentially what's being argued here, or at least some of the arguments of that. But what's being argued here is not a predetermined view on the case.
So here, do you mean in this case or in Gourley?
In this case here. So what's being advanced here by way of predetermined view in my submission, having listened carefully to the submissions this morning, is not actually a predetermined view of the live issue of whether or not the marriage was genuine, but a predetermined view of the strategy that was adopted. And I'll come on to the strategy and where that falls within the appeal. But that's my learned friend submissions focused on that. This is the judge showing that he's got a predetermined view against this strategy that's adopted. So the point I really want to highlight most is paragraph 23, where the court picks up a decision of the Court of Appeal in the Arab Monetary Fund in Hashim, and that's the remarks of Sir Thomas Bingham MR are put there, and I won't read it out to you, my lords and my lady, but you can see what's really being said.
Would you like it? Well, shall we read it?
Yeah, read it.
Anyway, just the quoted passage.
Just the quoted passage.
Very well. Yes, thank you.
So, in my submission, and particularly if this court is minded to give guidance, it's very important to underscore that a dialogue between the judge and the advocates is not necessarily something that's wrong or something to be avoided. And in this context, my lord, there's actually a further element which, in my submission, I'll come on to Maheshwaran and I'll show you what that is. But there's a further element here that a judge in the Immigration Appeal Tribunal is not just an umpire. So it's not like private law where the judge sits as an umpire and people make their case. You'll see that Maheshwaran was the context in the very often raised point, jurisprudence, and a very often raised point that a judge should have made sure this issue was covered. Fairness said. It's very normal in this jurisdiction, if a person's unsuccessful, for them to change representatives and then to say, well, all that went on before meant the proceedings were unfair, the appeal hearing or whatever was unfair because my representatives didn't deal with this or that or the other. So there is an awareness of a need sometimes for a judge just to make sure the ground is covered because it may be that there are issues relevant to the appeal, particularly relevant to the law, that need to be covered. And a judge, to some extent, bears a responsibility for that in a way that isn't true in private law proceedings. And I'll show you that in context in Maheshwaran, but I wanted to flag it up there. And the authorities that then follow from paragraph 29 onwards deal with this idea of where a court has, a judge has indicated views and concerns and how that plays into the appearance of bias or premeditation or predetermination matter. And you can see that the courts adopt an informed approach, that it's not enough to say that because a judge raises concerns and may raise them emphatically, that means that the judge has made up their mind on a predetermination or that they're showing apparent bias. So the court then goes on to suggest that if you're going to make these comments, just be clear that you indicate their preliminary views. And in my submission, that was plainly the position here. I'll come on to show you, but you can see the First Tier Tribunal judge at the end makes it clear he hasn't made up his mind, he's got a lot of material to consider, and that he will reflect upon matters and will make his decision. So
But it's not just whether there's been a preliminary view, but it's also the strength of the language used and the context in which the views are given.
I'm grateful,
Which
my lady, and I will
think is part of the appellant's submissions.
Absolutely, my lord, my lady, and that comes into the appearance of bias angle, as it were, so that the two are intertwined. Did the judge close his mind? Therefore, you had an unfair hearing, as it were, because you didn't have a hearing because the judge had already closed his mind. If it's not that case, then look at appearance of bias. Would an informed, impartial, informed observer consider that the judge gave an appearance of bias? Because that's important too. So.
But in fact, in these cases, we're nearly always going to be dealing with appearance of bias, aren't we? It'd be very difficult to show that the judge was actually biased. You can sometimes show such cases, but if they appear to have been, from the observations they may draw from giving preliminary views without adequate caveats, to have predetermined it, that would be an appearance of bias, and that's nearly always how the case is put.
Yes, my lord, although, of course, one looks at the judgment and what goes on too, because it must be real. There must be a real error of law here. There must be a real, it can't simply be, well, put it this way, in order for the concerns to be sufficiently serious, the fair-minded observer, there must be a cogency to them. There must be a foundation for them. It can't merely be impressionistic. There has to be some substance to them. So, if I could then just pick up Maheshwaran, which is in the skeleton argument, my skeleton argument. It appears at paragraph 9 on page...
We haven't got the authority itself.
Yes, it's in the authorities bundle. We can go to it there. But
I'd rather do that.
152.
I'm very grateful to my lady for that.
It's not a reported case, is that right?
Well, unusually it isn't. I think that might be just due to its age, because
No, I
maybe
know.
it wasn't picked up, because it's actually a very important authority, and it is, as far as I'm aware, the only authority specifically on this particular context, and trying to steer the course between these various difficulties of making sure that the ground is covered, as it were,
Yes.
but not departing from the proper role of the court, or the tribunal in this case, First Tier Tribunal. And I really wanted to pick it up. Paragraph 3 actually is helpful because it sets the guidance in context, and that's really, really important in this area, because there's a danger of the extraction of sort of statements, sound bites, and then they're used out of context. And an understanding that's shown here by Lord Justice Hima of how these hearings are conducted is obviously very important. And paragraph 3 is really dealing with this problem of the judge didn't put it to me, the issue wasn't, the judge makes a decision on a point and that concern wasn't put to me, and so therefore it's unfair. And you can see the warning at the very bottom of paragraph 3 is that adjudications, as they were be rightly cautious about intervening lest they give the appearance of bias. And paragraph 4 is undoubtedly a failure to put to a party in litigation a point which is decided against them can be grossly unfair and lead to justice. Must have a proper opportunity to deal with a point. And adjudicators have to bear that in mind, particularly with concessions. And occasionally it might call for the reopening of the poll, but that's not normal. But then paragraph 5, when much depends on the credibility of a party, and when that party makes several inconsistent statements which are before the decision maker, that party manifestly has a forensic problem. And I won't read it all out, but could I ask you to read paragraph 5, particularly noting the second half of the paragraph from undoubtedly?
Yes.
And then paragraph 6. is a statement in some ways of the obvious, but an important one to bear in mind. As I say, particularly if guidance is being given, because there is this danger of trying to recreate almost the conditions for an appeal, a sort of second set of rules on the conduct of the tribunal, which would be, in my submission, of concern, because the underlying idea in the statutory appeal system, it might be different elsewhere, but the underlying idea in the statutory appeal system is that you've had a negative decision, you go to the judge and you say, that's wrong, and the judge considers it and makes a decision on the underlying issue. Now, the decision might be just to dismiss the appeal, but very often the evidence only comes out at the appeal stage in this area. So very often the refusal letter doesn't play a lot of role in the proceedings, because the judge has evidence in front of him, up-to-date evidence, and can make a decision on all the material. Now, I appreciate there's a nuance in this context, and I'll come on to the nuance, the slight difference here, but to overcomplicate the proceedings with a very sort of legalistic approach that somehow restricts the role of the judge, and I'll come on to why I'm saying this, in my submission would be extremely worrying development and will lead to injustice, because the whole idea is litigants in person can come to these appeal hearings, that there aren't strict rules of evidence so that the judge can look at everything in the round. The general idea of can occur and is that the judge puts everything in, looks at it all in the round and makes a decision. And to lose that and to have it overlaid with unduly legalistic approach, or an approach that makes it complicated and difficult, in my submission, would be very counterproductive to the vast majority of those who use the tribunal. So when we come on to the particular circumstances in this case, that submission ties in, because if we could turn up the upper tribunal's decision...
Sorry, so this is all you're going to say about Maharaj Warren, is it? These are the passages you had in mind. So I thought I heard you say earlier that a slightly different approach obtains, or the role of the judge may be different in an context of an immigration appeal. And was that flagging the point that you have just made, which I understand, but when you first flagged it, I thought you might be making a point that the procedure wasn't adversarial, but it clearly is adversarial, isn't it?
I think sometimes it's been called quasi-inquisitorial. I'm not sure. These labels...
Well, that's quite important. That quasi-inquisitorial is different from adversarial. So which...
Well, Judge, I'm afraid the jurisprudence doesn't assist here, because sometimes some things are said and sometimes things... But certainly the form of the proceedings is adversarial, yes? And there's no doubt about that. And that's the basic form.
But one party or the other has the burden of proof.
May I come on to that, my lord, because it's a very important point. But
they do, don't they? I mean, it may shift around.
I can deal with it now if it would be
helpful.
Yeah, you do. But in my submission, the burden of proof really is a concept that's born of the idea that if you haven't got enough evidence, then the burden, the decision, the outcome will depend on the burden of proof. That's the genesis of it. That if the judge is there without sufficient evidence to really decide the point on the merits, the burden of proof tells you who wins and who loses. I appreciate that it's been developed but that is the genesis of the idea. That's why we have it, because what do you do if it can't be decided on its facts? In some areas of immigration, it's been said that it's not a very useful concept, because in fact what's happening most of the time is an evaluation of the evidence.
That's in the context of areas where the test is not either or, but real risk, as in the risk of persecution. That's the context in which certainly I've seen people say that the concept of burden of proof isn't very helpful in a real risk, but the test is real risk because that's much more evaluative.
And it's certainly right in that context, but it does appear in other contexts that this court, I can give you the authority, has said that it's not terribly helpful. But in this context, I appreciate it has a slightly bigger role, because there is quite a definitive role for the burden of proof here. And there's no dispute that the upper tribunal set the test out, the approach out correctly. There's no appeal in this court on an error of law, a misapprehension of a law, and I'll take you to that. But
well, you can if you like. But what's the point in taking us to something that doesn't matter?
well, Judge, because it does matter in the context of this case. What the point I seek to draw from it is there was no dispute about it. My submission is that despite the fact that there's no dispute about it in front of the upper tribunal, so it's not an issue, this is, we have different ideas of what the law says, an approach. The approach that my learned friends, all of my learned friends' submissions, apart from on the very final ground, in my submission, try to impose an artificial approach that's contrary to that approach by the upper tribunal. And would it be helpful if I just
which approach? Okay.
So paragraph. This is what should be happening in front of the upper tribunal. So if we go to paragraph 27. No, sorry, Judge, I've got that wrong. Sorry, paragraph 42, page 48.
Sorry, are we in the upper tribunal decision?
Yes.
Then it won't be page 48.
No, it'd be 100 and something, 130.
Sorry, I've got a different.
Paragraph 42, did you say?
Paragraph 42.
That's page 129 or internal 30. First stage, is that what you're taking us to?
Yes. You'll see the tribunal sets out what, and this is not disputed, what the approach is on these appeals. And as my lord indicates, burden of proof looms quite large in that approach. But you can see that there are 4 stages. And what's important...
Sorry, where are the 4 stages come from?
So, paragraph 42. First stage is the appellant produces a marriage certificate.
Yes, I see.
The Secretary of State considers the evidence, forms a view whether it's genuine, and if not, identifies grounds for reasonable suspicion. So that's the test at that stage. 3, the evidential burden shifts to the...
Sorry, I just want to... This is just what Judge Bruce says, but just I try to understand. Stage 2 is for the Secretary of State to consider whether her view is a reasonable suspicion that this was a marriage of convenience, and
evidence that's
so it's evidence is a verb governed by to consider, governed by to Secretary of State to evidence that suspicion. Yes, I see.
To produce evidence of that suspicion.
As I said, Judge, there's no...
Yes, is that right, by the way? It's not actually what we said in AGO, is it? I thought we said that the burden is not discharged merely by showing reasonable suspicion. That's the burden on the Secretary of State.
Shall I get to the end of the test, and then we can go back and look at it? But this isn't appealed, this, as being an error of law, and that's why I was emphasising that. So
well, it's wrong. It's wrong.
Well, then I need notice of that it's wrong, and I'll be able to sort of make submissions to you to show that it's
well,
right.
you've looked at the cases just as we have, but keep going. Stage 3.
The evidential burden shifts to the appellant to dispel the reasonable suspicion with evidence, and then taking account of all the matters, it is determined whether the Secretary of State has made out the grounds for the reasonable suspicion.
Yes. So, well, speaking for myself, I don't find that terribly helpful. It makes it all really complicated.
Well, Judge, the reason it's done like that is because of the way this appeal was being argued. And you can see that actually what the key underlying point, if there's one point to sort of take away from this, it's that what the upper tribunal judge is saying, and the first tier tribunal judge rightly did, was not allow an appeal to be dictated by the strategy of the particular advocate, in the sense that you can't stop a judge looking at something that might be relevant just because they may not need to go there, because they may stop at stage 2 or something. They may accept that the evidence of the Secretary of State is insufficient, just prima facie insufficient, as it were, and so may not go on to consider all the material. But a judge doesn't know that until they've gone away and thought about it. And so you don't stop evidence being produced at the appeal, which is really what was the underlying logic of this approach, was I'm entitled to stop the judge considering things and to force the appeal into a certain framework because I've taken this decision about the strength of my case. And it's not to say that advocates aren't entitled to have their own strategy. Of course they are. My point is, you're not entitled to impose that on the judge, to make it that the judge is not entitled to look at certain things.
Is that what is being said to have happened? I thought what's being said happened here is almost the other way around, that it's the respondents, the Secretary of State, who had set the issues by identifying the 5 reasons why the for believing that the marriage was not genuine. And what's been said is that being the reasons given, or those being the reasons given, it was wrong for the judge to rely on anything else.
And that's what I take issue with, Judge. That the underlying...
Okay, but that's not the advocate imposing that strategy. You're really saying, and I'm not saying this is wrong, but you're really saying that the First Tier Tribunal is not limited by the reasons given by the Secretary of State first time round.
Yes.
And let's assume you're right about that in principle. What do you say about the submission that if, which is I think Mr. Jaffergy's moderated position, if the Secretary of State wishes at the hearing to rely on matters that haven't been flagged up in the decision letter or in any review document, and or if the judge wishes to rely on such matters, fairness requires that the appellant know that that will be part of the issue.
So, Judge, that's bang on Maheshwaran territory. And what this court said in Maheshwaran is that sometimes fairness may require the judge to sort of flag up the issue or put the question or do whatever, but it all depends. And that,
well, it's not quite Maheshwaran, but they did say that, and I agree. But this is more about whether the judge, not just whether the judge must flag it up and ask questions about it. Maybe he can't flag it up and ask questions about it because it's not one of the issues before him.
Right. So Judge, going back to the beginning then, I'm sorry, I keep calling you Judge and it's too many Judge. I mean my Lord.
I'm not
so
taking offence, Ms. Anderson.
I really am sorry.
No, don't.
So take it back to the basics, right? The appeal, the issue on the appeal is always whether this is a genuine marriage, right? That, and I will make it good, my Lord, but that is the underlying issue. And right, as my Lord indicated, there may be reasons going one way or another for the Secretary of State's view, but that is the core issue in the appeal, because that's what matters ultimately.
Yep, no problem with that as the underlying issue, the ultimate issue.
Ultimate issue. That it's not a judicial review of the Secretary of State's
No,
refusal.
okay, got it, yeah.
And one thing that really indicates that is that actually, even if an appeal judge agrees with the Secretary of State on what was before the Secretary of State, if there's new material,
yeah,
there's further
you're pushing
evidence,
an open door, Ms. Anderson. Yeah. All this is ABC stuff. Yeah,
I'm building it up because it does bring you to why it's wrong and artificial and incredibly damaging to try to restrict the appeal to only things that were said in the reasons for refusal letter. That were only, it may be you have to accommodate things later, as it were, but on that basic idea of whether a judge can look at it or not, whether an appeal can take it into account or not, these issues, in my submission, it's absolutely crucial, axiomatic, that a judge can look at issues that come out of the material in front of the judge, that come from the law, that come from...
Well, can we test it with an example, as it happens, taken from this case, but you needn't worry about whether you actually say it's what happened in this case. Suppose it has always been accepted by the Secretary of State and found by a tribunal that the previous marriage was genuine.
Yes.
And suppose that the judge forms the view, looking at all the material and in front of him at the hearing, some of which was always available, some of which came out of answers that were obtained, doesn't matter by him or by someone else, that actually the first marriage was also bogus and that was relevant in deciding whether this one was. Surely, well, the first thing that I think you would accept is that the judge must put that concern to the appellant who had no notice of it. And if the judge raises it and the appellant or the appellant's counsel says, well, we had no idea at this point it was going to be taken until now. It's extremely unfair to take it now. I appreciate that the underlying question is whether this marriage is genuine and therefore the genuineness of the past marriage might be relevant to that. Still, as a matter of fairness, it's too late to take that point, whether it's taken by you, Judge, or by the Secretary of State, because we didn't see it coming until now. And then the other party might say, well, if you're really prejudiced, you can have an adjournment. And then you get into case management territory. But it might well be unfair to have an adjournment. Now, that is simply an example that your proposition, which I take it to be, that essentially everything is up for grabs at the hearing, irrespective of whether it's been flagged up in the decision letter or in any other way beforehand, goes too far. It will be the issues at the hearing will be constrained by fairness, and that will be effectively means be constrained by points of which the other party had noticed or could reasonably have seen coming.
Yes, just on that specific example, this might be too specific, but my lord will be aware of Refusal, and Refusal was on this very point where you'd had a whole hearing under the Refugee Convention about something in which credibility would probably be one of the issues. And then once the Human Rights Act came in, the question was, well, you're going to have all these hearings again under the Human Rights Act. What do you do with previous determinations? What do you do with the fact that you're going over the same territory? And so the courts had to resolve that, and it was resolved by saying, and I think we're in agreement on it, that the starting point is the previous judicial findings. So you don't ignore them altogether, that's the starting point. But you are entitled, if you have new evidence, and if you are actually hearing a witness on something and seeing them give evidence and what have you, you are entitled as a judge to form your own view on it. But you must take the starting point as the previous determination.
Only the starting point.
I'm afraid that's how it is. It's the starting point. And so in my submission, there's no hint anywhere that, and indeed the whole way the rules are set up is that the tribunal can take anything into account. If you look at the evidential rules, that's essentially because they're trying to get to the right answer. That's the ultimate underlying idea here, is strip away all the complexities that might be elsewhere and try to get to the right answer. That's the sort of a fair and right answer. And fairness is important. And that's why, as you put to me, my lord, it may be that if you're introducing something truly new that couldn't have been envisaged, and Maheshwaran says, people have to be on notice here, to a certain extent, that these are, credibility is going to be an issue in a marriage of convenience context, because that's what it's all about, essentially, underneath it all, is this. These parties are saying this is a genuine marriage. Is that the right answer, as it were? That's the underlying situation. And I appreciate the burdens on the Secretary of State to show it isn't the right answer. And so that's why you have burden of proof in there. But it's still that underlying question. And that's why you can't constrain your judge by your tactics, by your strategy. And you can see in Maheshwaran, the court anticipates that the strategy of some litigants may well be, least said, soonest mended, that you don't highlight the inconsistency in your point, you don't put your client up for cross-examination, you don't sort of in some ways allow the testing, because it might make things worse. And so there is a perfectly ordinary strategy of not tendering your client. But really the essence of this case is, by doing that, you can't constrain a judge. You can't therefore have a win-win situation where you therefore somehow put artificial restraints on the hearing that mean the judge can't consider certain matters because your strategy has been this sort of idea of, well, we don't have to raise it because it's not relevant, or whatever the justification is given. And this might be, I don't want to delve into the evidence too much, but there might be an important point here about the strategy, which is worth turning up. And actually, I'm going to take it in turn when we go through each of the criticisms, but just to herald it, that when you see the judge ask the appellant about why the witnesses aren't giving evidence, and I will go over it, but I'm flagging it up now, you'll see his answer wasn't, I was advised that our case was so good we didn't need it because the Secretary of State hadn't proved her case or his case, depending on the time. He didn't say, I even did it on the advice of advocates. If you read what the appellant said, he said, I didn't think the evidence would be believed. And so
I'm not making a note about this now.
I will take you to it.
I'm not a great believer in flagging points in advance,
right,
because it's a little bit confusing for the court. Okay, yeah.
I'll take that, my lord. So, in my submission, if nothing else comes out of this case, the importance of leaving these judges free to consider the evidence and to let things develop and then make their decision afterwards on the basis of all the material.
Including by taking points which the advocate for the Secretary of State hasn't taken and which the other side couldn't have seen coming?
That all depends on the circumstances. That is Maheshwaran, my lord, and that depends on the circumstances. What the court says in Maheshwaran is some of these are obvious. If credibility is an issue, if there are inconsistencies in evidence, you have a forensic problem. And you can choose to deal with it or not. And in all fairness to the submissions of the presenting officer, you'll see that she did say that the explanations were not good enough. So it wasn't that these matters were not addressed. You can see some of them were addressed by the appellant in his evidence, his oral evidence, by the judge in my submission quite rightly clarified, and I'll show you why he's quite rightly clarifying. But in any event, the submissions of the presenting officer was to say that the explanations that have been given are not good enough. They don't explain away the inconsistencies. So everyone knew that these points were there. They were live. You don't need a presenting officer to have to make them. And it's absolutely normal in these proceedings, and that's what the Maheshwaran decision reflects, that where credibility is an issue, particularly where discrepancies have been raised, that there is a need to, if you're not going to accept those inconsistencies, if you're going to explain them away, to address them. And it's still open to a judge to consider those explanations without a presenting officer sort of going over the ground again and asking questions and more questions. If they're not adequate explanations in the judge's view, then they're not adequate explanations. And you might appeal the judge on the fact that his findings aren't correct, etc., etc. But that's not this appeal. And although we've had a lot of submissions on the underlying merits today, I would ask...
We had no submissions on the underlying merits.
Well, in my submission, there's quite a lot of points were made about whether or not that was a good point or a bad point, or whether or not the judge was entitled to find that in the judgment. But if my lord hasn't taken account of them, then I have no difficulty with that. I ask only that you bear in mind that this is an appearance of bias, that there's always a temptation to sort of look at the underlying case, and it's hard not to sort of form a view, but all the time we have to come back to the appearance of bias here and the arguments that are being made in this particular context, because those are the ones that were operative in the court below, in the tribunal below. my learned friend very diligently took you through all the materials, and I don't propose to go back over that. I think, may I just flag a few points, and if you need me to go back to the matters, I will. But looking at my learned friend's submissions, it's common ground that it was the immigration history of this individual that led to the Secretary of State's investigation. You see that we saw that in the materials, and that will be relevant when we come on to the particular criticisms of the First Tier Tribunal judge and how the Upper Tribunal dealt with them. So it's common ground that that background was in the frame.
Oh, well, hang on. What do you mean by in the frame?
Because that led to the investigation, my lord.
Yes, but there's a crucial difference between, well, it may not be crucial, but I'd like to know why you say it isn't, between the immigration history being the trigger for an investigation and the Secretary of State deciding not to refuse the certificate for particular reasons. Unless, I think really what Mr. Jafferty said is, the Secretary of State has a choice. He or she can rely on the particular reasons, and that's what was done here. Or instead, I can rely on the particular reasons taken in the context of the immigration history, which is not what was said here.
Well,
Mr. Hima will not know at all what triggered the investigation. He'll only know what the reasons are why his thing was refused. Might, in fact, have been triggered, apparently it wasn't in this case, might have been triggered by a report from somebody.
Well, my lord, in my submission, that's another example of this wholly artificial approach, which is of real concern, that the investigation is triggered by the immigration history of the individual. And yes, that's right in terms of the mechanics, as it were. But the underlying issue, always in these cases, is credibility and is the reliability of the witnesses. Because underneath it all, it's always the case that the individuals are saying, this is a genuine marriage. Trust us, this is a genuine marriage. And the Secretary of State might investigate and accept it. And in that case, immigration history, it might have played a role in investigation, but you can see the Secretary of State considered the actual marriage, considered the statements of the individuals after seeing them in interview, and will either accept it or not. So it's wholly artificial to say that where the Secretary of State says in very clear terms, I do not accept that this is a genuine marriage. I've seen you in interview, I've seen you both give evidence, I do not accept a genuine marriage. That always that means, for these witnesses who have said time and again, this is a genuine marriage, that the reliability of their evidence is not accepted. And that brings credibility in. And you cannot try to extricate it. And the complexities that would arise if you tried to abstract things and somehow ring-fence credibility in a marriage of convenience appeal.
I'm just testing it this way because we may be asked to give some guidance about this. One way in which Mr. Jafferty put his case was, it's not difficult for the Secretary of State. If the Secretary of State intends to rely on the immigration history, which in some cases may be obvious, in some cases may not be, all they need to do is add a paragraph to their decision letter saying, here are the things that came out of the interview, and in deciding whether I accept, whether I think these are genuine, genuine mistakes or signs that it's not a genuine marriage, I take into account your bad immigration history and findings made against you on a previous occasion and so forth. Then the other party will be on notice. If maybe something has been said against them in an earlier tribunal decision, they can get out that earlier tribunal decision and see whether the Secretary of State has accurately reflected it, and so on. But what's so difficult for the Home Office in just adding such a paragraph, if that is part of their reasoning?
My Lord, I'm not sure there's a difficulty in adding it. What my real concern here is that this is not a judicial review of the Secretary of State's letter, the appeal. The appeal is the opportunity for these issues to be raised and explored. And
well, can I just pause you on that? I'm sorry to interrupt. It's just, of course, it's not a judicial review. You're quite right, and I absolutely accept, as I said, you're pushing an open door, that the hearing is a de novo hearing. Anything relevant can be brought in, whether it was known about at the time of the decision or not. But it's still got to be raised. There's got to be some form of pleadings. And in practice, the Secretary of State's pleading is the decision letter, because there isn't anything else. Nowadays, I think we gather there's a review, which is a form of reply or rebuttal. But the primary statement of the Secretary of State's case is in the decision letter. And the skeleton argument in support of the appeal will be the statement of the respondent's case. So it can't be completely unconstrained.
I understand the point you're putting to me, Judge. My answer is this, that if what's said is, if it's not in the reasons for refusal letter, how could anyone have known that credibility was an issue and that my immigration... Well,
it's not so much that credibility is an issue, but particular points being relied on as damaging my credibility.
Okay, well, my immigration history wouldn't... I didn't know my immigration history would be relevant to this. In my submission, that really verges on the absurd in this context. It really does, my lord, because immigration history, in the context of whether you're manipulating the immigration system to your advantage, is always relevant. And
I thought it might vary from case to case,
it might be relevant as a positive, right? It might be absolutely relevant because the individual has never done anything like this before. And so their clean immigration history, as it were, you know, the fact that they've queued up, they've applied for their visas, they've paid the fees, they've given the evidence, they've left when their visa ran out, they've done all those things with compliance, that would be a positive, my lord. And so therefore, the immigration history would show that it's implausible, as my lord put it, or less plausible, that they would enter into this deception of a marriage of convenience.
Okay. No, I see how you...
But the other way around, of course, you know your immigration history. You may want to draw a veil over it, but whether you can exclude a judge from looking at it because it's not in the refusal letter. In my submission, again, it's this artificial approach of putting constraints on what can be considered. But I accept the fairness point, you know, if it's come as a big surprise that the immigration history, well, I think people ought to know, if you're professionally represented, you know, you do look at these issues and you may not want to say much about them, but you know they're there. A litigant in person, I think it might be a more sympathetic situation where they just genuinely might not have thought it could come in. And that's the case where perhaps there's a stronger idea of it being sort of raised and so it can be dealt with.
No, thank you, that's very helpful.
So, Judge, if we, I'd like to pick up my skeleton if I can, because it gives me the references, at page 8. And this is looking at the hearing before the upper tribunal and the issues that were before the upper tribunal. And in my submission, it's important to just be clear about how the case was put below. I'm not going to take exclusionary points on this.
So what paragraph are we on?
I'm sorry, my lady. I think paragraph...
into paragraph 10, doesn't it?
The upper tribunal judges...
No, you
yes,
wanted...
I'm picking up a paragraph 10.
Your skeleton at paragraph 10.
I am picking up a paragraph 10. And the ground of appeal certainly appears in paragraph 11, I'm very grateful, my lord, which is about the appearance bias. But there is a slight moving from the grounds of appeal, which are there at upper tribunal judgment, paragraph 9. You can see that there is a sort of, as often happens in...
Sorry, I've got lost. Paragraph, where are we?
Paragraph 9 of the upper tribunal judgment.
I'm sorry, I thought we were looking at your skeleton argument. Oh, I got
yes,
muddled.
Paragraph 10 that I make this point.
Paragraph 10 of your skeleton argument says the SSHD highlights the following aspects of the decision under appeal.
Yes, I've gone on to paragraph 11.
Paragraph 11. Okay, got
up,
it.
Upper tribunal judgment, paragraph 9. And that's the grounds of appeal. All I wanted to do was just to sort of indicate that there was a certain amount of sort of digging in and refinement at the tribunal hearing to consider what the essence of the appeal really was. And that's where we come to the sort of fair hearing apparent bias. And it was made clear in front of the, sorry, I'm just trying to find the paragraph, my lord, that it was made clear in front of the upper tribunal judge that there was no allegation of actual bias on the part of the First Tier Tribunal judge. It was solely appearance of bias. And as I say, we've already covered that ground, but it's important in the context. So we can't extrapolate from anything this judge might have been in the past, etc., that there was actual bias in this case. Then if we look at the judgment, I don't really want to go into, I'll come back in turn to paragraphs 20 to 23.
Which judgment are we on? The upper tribunal judgment?
Tribunal judgment.
Yes, right.
Because that's the point about the...
Sorry, did you say you're not taking it?
Well, I'm going to take it in turn. I'm just perhaps explaining why I'm not going through my skeleton argument in order.
Don't worry about the skeleton. The most helpful thing for us is to have your submissions. If they're going to be by reference to your skeleton, that's fine. But if they're not, don't worry.
Right.
It'll only confuse us.
My lord. We've already looked at the approach that the upper tribunal took to the stages. It may not have been helpful to put it in the 4 stages, but the upper tribunal looked at the matter and explained that that's what's really happening in these appeals. And at paragraph 15 of my skeleton, which is paragraph 28.
Sorry.
Paragraph 28 is the upper tribunal decision. You can see that in all fairness to the upper tribunal, the conclusion that the upper tribunal gives there, the overall conclusion, is an overall conclusion on all the points that have been raised. It's clearly looking at appearance of bias. What the tribunal is not doing is saying, well, I found unfairness, but because overall the proceedings were fair, it's okay. What the judge is doing there is applying the test. The judge has stated the issue and then gives the overall conclusion, and then goes on to break it down to deal with each of these submissions that have been made to the judge as to why there was an appearance of bias here. And there were 6 reasons for that, which were pursued by the appellant's representative in front of the upper tribunal. And we'll come to each of those in turn, but while we're looking at the overall structure, if we can look at paragraph 41 of the upper tribunal decision, you can see that...
I'm sorry, may I just interrupt for just one moment? In paragraph 28, where the judge said there was at one point in particular a deviation from the norm, was that a reference to what we see in paragraph 34, where the judge was talking about what regarded as the most problematic part of the hearing?
Yes, I think that's right.
Is that because I'm not sure otherwise, I may have missed it, but which bit of the judge's behaviour was the deviation from the norm?
My lady, I concur with that. Obviously, I can't say for sure, but that's how I read this. That the overall structure is the judge looks at the 6 reasons given. Well, 4 of them says, really, I think you've misunderstood here. There's no substance to those at all. They're just misunderstandings, really, or they're unfounded by the advocates. And then for the 2 of them, that's what was of particular concern to the judge. And in my submission, the judge then goes through them and explains why a fair-minded observer wouldn't think that was an appearance of bias.
And so would you, on behalf of the Secretary of State, accept that the way the judge dealt with the matters at 34 and onwards were a deviation from the norm, and therefore capable of amounting to unfairness?
Well, what the judge is doing in my submission her job, which is...
I'm asking you whether...
Well, my position is
the judge has referred to it as a deviation of the norm, and I'm wanting to know what your position is on a judge who there's a finding that they've done something that's a deviation of the norm, where the allegation is that that's amounted to unfairness.
In my submission, there is a difference there. That many hearings take unusual courses, as it were, a deviation from a norm, and that's part of the flexibility. So a deviation from a norm in itself...
we are talking in the context of what's just been described in the previous sentence as fractious and frustration.
Yes,
so it's not just saying, you know, we're going to deal with it this way because of the unusual circumstances. This was a deviation of norm in the context of what was proving to be a very difficult.
Before you answer my lady's question, the other bit that's clearly compassed in the deviation from the norm is para 38, which all the paragraphs are all as a whole, where she says that Judge Mills's intervention was capable of conveying the unfortunate impression that the tribunal was contemplating taking its frustration with the legal representative out on the appellant, and in the next paragraph refers to legitimate cause for complaint. So I think the phrase deviation from the norm, which we're focusing on because it's what the judge said, looking at actually what she found, is not just some unusual thing, it's some unusual and wrong thing.
Yes.
Giving rise to legitimate cause for complaint.
Yes, that's why I wanted to be careful in answering the question, in that I'm not saying normally a deviation from a norm would mean an appearance of bias or something unfair because of the flexibility of these proceedings. I would understand this tribunal to be saying, in this context, this course, I'm not sure quite how to phrase it, but the relationship between the advocate and the approach to the bold strategy, that's the way of putting it, that's where things are deviating. And in my
it's not the advocate's approach to it, it's the judge's response to it that we're worried about. I mean, we may think the advocate got their tactics wrong, but that's not the point, is it? It's the judge's response, which was a deviation from the norm.
And the question is whether the judge's response is understandable in the context, or whether the judge's response... Well, my lady, I'll come to it, but you see the upper tribunal judge looked at the root of the problem, right, the bold strategy, because without doubt, what made this hearing different and unusual was the bold strategy, this approach of, I'm just going to rely on burdens of proof and this sort of idea.
And is that unique in your considerable experience?
I don't want to give evidence, my lady. I don't do enough of these to reliably say.
Right.
But I would certainly say that faced with an option of giving the best evidence, having the judge look at your couple and all these things which, from the Secretary of State's point of view, is really difficult to answer.
No, I'm not talking about best route or best way of presentation. It's just
it is unusual not to use all your assets, if that's the way of putting it. And to take a legal point, a very legalistic approach, is unusual. It's not normal in this context, which, as I say, is an appeal, a tribunal appeal. It's not the High Court with judicial review and forensic points about the law. It's an appeal where you go, and the ultimate question is always, is this a genuine marriage? And therefore, it would be normal to think, let's put all the evidence in front of a judge that could help us and could do that. It's very unusual to take an approach of just saying, I'm going to rely on a particular legal submission and say to the judge, that's it. You know?
Yes, but then come back to my lady's point, which is, okay, the advocate has taken a, let us assume, unusual course, which the judge regards as rather artificial, very artificial. How does he handle it? Absolutely. He is openly highly critical and asks, and perhaps this isn't the right point to raise it, but elsewhere in the hearing, because clearly these incidents are all connected to one another, he actually asked for the appellant's apology, the counsel's apology for having taken a perfectly legitimate point. Well, perhaps you wanted to come back to that point. Okay, that's a bit unfair.
This is where I was wondering how much to go into each bit of the but I think I will deal with.
It's my fault, and I rather poached my lady's question. So I'll let her finish her point, and then you can come back to mine later.
So just on those stepping stones on the way, as it were, I hope to come to them, my lord. But if there's any of the stepping stones I missed that is of interest, please raise that with me, because I'm going to hopefully I will deal with the key ones, but I'm not going to go through every single one.
Yeah.
That was,
well, anyway,
comment that was made.
Well, we've got your skeleton argument, so we know your points.
Yes, but I didn't actually. Obviously, I haven't heard my learned friend making the points on every bit.
Well, don't worry. You make the points you want to make.
But I want to answer my lord's question, well, my lady's question really.
Yes,
I want
answer
to
my
answer
lady's
that
question.
because I think it is absolutely the heart of this appeal, and that is a decision for my lady and my lords, which is: did this judge do as the upper tribunal found, knowing about this area, do what Maheshwaram says could and sometimes should be done, which is express concerns about this strategy. Ensure that the possibility of adverse inferences being drawn from not putting your witnesses who put in witness statements, not putting them on the stand, as it were, to give evidence. Stand sounds a bit dramatic, but give evidence, not allow them to give evidence. The adverse inferences could be drawn, and that's absolutely uncontroversial. That's absolutely normal. My learned friend, I will deal with the submissions on that. But so, Judge, make sure that's clear, really clear at the outset. The judge indicates his misgivings about it, that this doesn't seem fair to the appellant even, and so is making sure, because as I say, advocates are often blamed for hearings going wrong, so making sure the appellant understands. And Maheshwaran says, in certain instances, the judge has to ensure that these things are ventilated.
Well, let's just say, it's another one of my lord's open doors, and
right.
For my part, say I accept that in its entirety. But it's how it's then put. If it's put in a way that where the judge, looking at 38, demonstrably unhappy, fractious, turn of phrase, capable of conveying unfortunate impressions, capable of unfairness. The fact that a judge may be conveying information which is appropriate and is necessary, you would say particularly if one had litigants in person, but it's done in an aggressive, unpleasant way that leaves the appellant feeling that they've had a very unfair hearing.
Well, my lady,
that's something that a court has to consider. But that doesn't mean to say that the substance of what they were conveying was illegitimate, does it?
No, absolutely, my lady. I think
so
that
what we're
whether it's a good
concerned
point
about is how this judge behaved and the impact it had on the fairness of the proceedings.
Absolutely, my lady. And this is what the court must decide. My submission is this, that I've been in many, many fractious hearings, I hope it's nothing to do with me, where judges were frustrated, particularly in immigration and asylum, often to do with documents, but can be incredibly rude, and I know that's not the ideal, but it happens, and I'm not excusing it in any way. I think the highest standard of conduct must be aimed for. So it's not to in any way condone behaviour where a judge perhaps becomes too terse, becomes too abrasive, and particularly with a litigant in person or somebody who's vulnerable, oversteps the mark. So I'm not making a submission that there shouldn't be the highest standards of conduct, because of course there should. But the question is whether a fair-minded observer, seeing the context here and understanding that what's happening here is the judge is raising concerns with the advocate, and the advocate is persisting in a strategy and making submissions, and I will come on to the individual point, but when it comes to the idea of what the judge has been criticised for, being not even-handed and blaming the advocate for this, that and the other. In my submission, when I go through it, you'll see those aren't fair comments.
Well, except you're not wanting to go behind the Appellate Tribunal's decision at paragraph 39, that there was an acceptance that there was a legitimate cause for complaint.
In terms of perhaps some of the manner of the judge, although in my submission you've heard the audio tape,
yes.
One was expecting, given that what's being said here is that the judge's bias is an appearance of bias, not an appearance of bad temper, and not an appearance of being fractious. That's not an indication of bias, and maybe there's a difference. Just like it's unfortunate that advocates are sometimes disciplined within judgments rather than having actually a system where if you're discontent with an advocate and their performance, it can be done in a normal procedural way rather than appearing in a judgment or appearing in submissions. But unfortunately, in this context, it is the case that it's often in the hearing and in the judgment that these matters are aired. And so there is that overlapping. But what matters is whether that affects the underlying consideration by the judge of the issues, and it makes them biased, or at least appear to be biased. And that's really the Arab Monetary Fund point, that in this area, there is often, in an adversarial system, a dialogue where a judge can be quite forceful in putting the points to an advocate and displeased with an advocate by pursuing a particular course of action. But that isn't an indication that the judge is biased against them. It's appearance of bias. But you've got to look at what bias is to appear biased, as it were. Because if what you have is the appearance of what often happens in the course of proceedings, then that's something different. Actually appearing as if you are deciding against this appellant because you don't like their advocate or you don't like their advocate's strategy. That is the underlying, really worrying submission here, that judges will be judged on the way they deal with the advocates, that will actually mean, you can take from the way they treat the advocate, that that's going to mean they're biased in their decisions. That's really what's being said here. It's not a is this the ideal way of handling a hearing? Is this the highest standards of conduct, etc., etc.? It is an allegation of appearance of bias. And in my submission, that's a very serious allegation, that you think the judge has taken against the individual so much, or a strategy so much, that they appear as if that's going to affect their decision. And I appreciate these are difficult, and it's very difficult in abstract to outside of a hearing, as it were, when one looks at things in black and white. It does appear. Obviously, everyone wants the best standards and politeness throughout, but that's not an informed, fair-minded observer would know that's not actually, unfortunately, the situation that's always possible with human beings in a normal environment, where there's someone who's really concerned that the appellant may not be putting their best case forward and may be holding away from a judge. You can see what his concern here is, that by this strategy there might be material that's helpful to the appellant that's not coming forward because the strategy of keeping it back has been put forward. And so you can see the real concerns for the appellant here. And I say that is obvious from the comments of the judge. But the judge is saying, that's what he means by you're not doing your clients any favours here. It's not that I've taken so much against you that I'm going to decide the case against you because, we've now had a breakdown of relationship and I'm going to decide. It's by your strategy, you are denying this evidence that would normally be there, normally coming forward, and you're holding me out of looking at that material that could be helpful because you've taken this very legalistic approach. And in my submission, it was open to the upper tribunal to look at all those pointers and look at what the judge says. And you can see that on a balanced approach to the judge, not just picking out the bits where matters got a bit tense, but looking at it overall, would you form the view that this judge decided this case, or appeared to decide this case, on the basis of an animosity. I can't remember how my learned friend puts it, but a sort of breakdown of relationship with the advocate. And in my submission, you wouldn't fairly do that.
Thank you.
So when we look at the points that the upper tribunal go through, the upper tribunal identifies, as I say, at paragraph 41, the root of the difficulties, and I don't think there's any dispute that that's what affected this hearing. The explanation that's given, I did want to pick up, I'm not going to go through all the points that my learned friend made this morning, but I do want to pick up in the bundle the point about the judge and the questioning. So page 205, sorry, of the bundle. So this is a situation where it's clear that adverse inferences may be drawn about the absence of witnesses providing evidence at the hearing. And so the judge is following up the questions about why this is the situation, to see if there's a good reason why they're not here, because there might be, and you see that some reasons came out from it, potentially came out from it as explanations. So the judge asks, sorry, this is a cross-examination question. So bottom of 204, you asked a question, why have you not produced other evidence, etc., etc. And this is a cross-examination question by the presenting officer. So can I take from the question that...
I'm so sorry, I've just lost where you are.
Page 204 at the bottom.
Thank you very much.
The bottom of the page.
Thank you. Yes, do go on.
It's the very last sentence, my lord. So can I take it from the question you put to the Home Office that your answer as to why you did not produce other supporting witnesses is you do not think you should have to. Is that right? So that's that key point that's being put. That's the explanation that's being put forward here. So to begin with, it's yes, that's right. So because even if I take someone else, I don't know who you are thinking, be he friend or whatever, still you are not going to believe. So I don't know what to do. So in fact, the answer is, I didn't bring other witnesses because I didn't think you'd believe them. So then Judge Mills explores that with the follow-up questions, because it's not as it's been put this morning, that it's a simple question of, this is the strategy that was adopted and that's why the witnesses weren't there. And he tries to explore whether there were good reasons why the witnesses weren't there, because there might have been. And that's what he's doing there. They are legitimate clarification questions, because that answer wasn't clear, or was certainly not conclusive. And it was legitimate to then clarify the position of the witnesses, because although the advocate may have said, I don't need to go there, if there were good reasons why, as I say, they couldn't attend, then that was something the judge ought to take into account when being asked to draw adverse inferences. And you can see the presenting officer did ask for adverse inferences to be drawn in the absolutely normal way. And although it was often said that the judge put words in the presenting officer's mouth, one has to bear in mind when those exchanges took place. The exchanges took place before the presenting officer had a chance to present her case, as it were, and go to her case. And all the judge was doing was running through the possibilities of what he would expect to happen, and quite rightly would normally happen, when discussing this idea of the bold strategy. Is this, bear in mind that if you adopt this strategy, you're going to face this problem, face this. And that's the context in which that examination was being conducted, as it were. It wasn't fair to say that the Home Office presenting officer wouldn't have said this, but for the judge saying it. That's simply not a possible or even fair conclusion to say, because it's the Home Office presenting officer's job So this is what you do in every hearing almost, is you ask the judge to look at the materials, and adverse inferences is an absolute stock in trade of what you would do if witnesses hadn't come to give evidence, because there's not much else you can say. So that is what would normally, the court's been denied the benefit of the witness, you'd expect these questions to have been considered and drawn adverse inference.
So your case is that the judge's questioning was entirely appropriate.
Yeah,
So you profoundly disagree with Upper Tribunal Judge Bruce.
what Upper Tribunal Judge said was it was unnecessary.
No, entirely unnecessary. The reason the witnesses were not called had been made clear. It's difficult to see why there was any need for further clarification on the point. That's what the Upper Tribunal Judge said.
Yes. And
with which you disagree, presumably.
Well, all I would say is that the Upper Tribunal Judge also indicated that the First Tier Tribunal Judge was concerned about the strategy that was being adopted and the effect that that would have on the hearing. And in that context, in my submission, it was inconsistent with that the judge was drawing out, when you look at what the questions were about, was drawing out the circumstances in which the individuals didn't give evidence. Now, the Upper Tribunal Judge may have considered it was unnecessary, but that's not the same as saying it was inappropriate.
Well, he said there was a legitimate cause for complaint.
About the number of questions in there. But the cause for complaint, in my submission, is distinguishing between, if you read the decision as a whole, distinguishing between those areas where the Upper Tribunal clearly thought there was no cause at all for complaint, that what was being complained of was things that were not actually right. And the Upper Tribunal Judge, if we look at the judgment, you'll see that's what actually the Upper Tribunal goes through. With those first points that are looked at, the Upper Tribunal Judge carefully distinguishes between the 4 points that were seen as not well-founded and were not really a cause for complaint, and the 2 that were the cause for legitimate complaint. But that's not the end of the judicial consideration. That's what the judge then focuses on and says, does this show an appearance of bias? And set in the context overall, as they must be, and understanding why the judge was taking the approach he was taking in that context. The Upper Tribunal found that they were not showing an appearance of bias, because taken in context, one can understand them. So, in my submission, all that's happening there is not a finding by the judge it was unfair, that it was wrong. The First Tier Tribunal Judge did something that showed an appearance of bias, distinguishing between fractiousness and, short-temperedness, which, as I say, unfortunately, is not a rarity. That the distinguishing between that and an actual appearance of bias, you're going to make a decision on the wrong basis. In my submission, the Upper Tribunal looked at these 2 matters of concern and said that a fair-minded observer would not reach that conclusion. So it is important to focus not just on the frustrations with a judge who may not have expressed himself perfectly throughout and may have become frustrated. Distinguish between that and this appearance of bias, because if that counts as bias, in my submission it's incredibly problematic to actually apply that in practice in the context of adversarial hearings, particularly in this jurisdiction where different approaches are taken, and judges might often want to guide advocates to focus on things that are the correct questions. So, paragraph 39 is really the crux of it, where the judge explains, the Upper Tribunal explains why the fair-minded observer would not consider the show that the judge was apparently biased in the decision he was going to go on to make. 40 to 41 go further to explain how these two matters of concern would be understood in the context of this hearing. So in my submission, those are the sort of crucial parts of the upper tribunal judgment in this respect, 39 to 41. And may I just pick up some of the individual points that have been made by my learned friend in the course of his submissions, and I hope that this will also perhaps be an entrance into the second main area of the appeal, which is about the upper tribunal judge making findings, and this question of the visits. This does also key into the point about, my lord put to me about cross-examination and the judge being accused of cross-examination, etc. And whilst he may have had an immoderate reaction to that, in my submission it's not unfounded in the sense that it was an accusation or an allegation of cross-examination.
Well, it was, but
Well,
why?
it was.
Well, in my submission it wasn't. But
Well, in a sense, it doesn't matter. Whether it was cross-examination or not, you shouldn't have any moderate reaction to counsel making a legitimate submission. Counsel believed it was cross-examination. It was at least some reason to believe it could be characterised as such, and the judge should have dealt with it in a calm and professional way.
my lord, I can't argue against that. I'm awful.
So one of the things
I'm awful politeness.
Can I just flag?
Yes.
One of the things that I'm concerned about, Miss Anderson, is you've told us several times that the tribunal judges are, you said not uncommonly, short-tempered and rude and irritable and intemperate and immoderate. Those are the words I've noted down. Now, there is now a statement of expected behaviour, which was published sometime in 2023, about how we as judges, all of us, anyone that's a judicial office holder from First Tier Tribunal to the Supreme Court is expected to behave, and I can assure you that it doesn't anticipate routine, short-tempered rudeness, immoderate reactions. And your submission, however, seems to be, well, that's just the way it is. And providing they get somewhere near the right decision, and people appearing in front of these tribunals just have to put up with it. And that, I'll just tell you for my part, that concerns me greatly.
That's not my submission at all, my lady. And I wasn't talking about First Tier Tribunal judges. I was saying that in my
First Tier Tribunal
30 years
judges, I think you were
experience
talking.
of doing these cases, that the experience has been, and maybe from 2023 onwards, the experience will be different. But the experience has been that with the pressures of hearings, particularly in this court where the time pressure is extremely harsh, that there are occasions where under those pressures the hearings become conducted in a manner that everybody would probably agree, including those involved afterwards, does appear to the outside observer to be particularly terse and aggressive and what have you. That particularly where a judge is trying to get an advocate to get to the point or to cover something important or what have you. And sometimes it's judicial language, sometimes it's I have your submissions, and sometimes it goes further.
And there has to be, sometimes there's a line that is crossed.
Absolutely, my lady, and I'm
And
in
the case
no way.
is this a case where the line has been crossed?
Well, my submission is it isn't, and this is my submission, that if you listen to the audio recording,
Which I have.
and you listen to it all, and you listen to the whole hearing, as it were, so although there may have been points of stress, if you see how the judge at the end, very fairly to the appellant, is explaining, and in my submission, it's not fair to characterise it overall just on the negative sort of aspects that there. If this is not a case where the judge, in my submission, has gone too far over the line. I'm not at all advocating for behaviour that is anything other than polite and constructive and how we'd all hope it to be. What the point is here, though, is whether this behaviour is sufficiently serious to say that this judge gave an appearance of bias. And bias is such a serious allegation to make.
Or put another way, that somebody came away from that hearing thinking, well, I haven't had a fair crack at the whip.
Well, that's the point I made, Judge. There is a distinction between those involved in the hearing coming away thinking they haven't had a fair crack of the whip, because otherwise we'd never get any hearings done, because one can't help but often feel that. But there's a difference between that and the fair-minded observer.
Yeah, never mind the fair-minded observer. The fairness of proceedings is the requirement that the proceedings are conducted fairly is to make sure that the parties understand that they're being dealt with fairly. I mean, in criminal cases, defendants may be accused of the most horrendous crimes. They're dealt with fairly, and the judge ensures that everything is done to ensure that their case is put properly and fairly before the jury. That's a criminal case. Civil cases, a judge must conduct the case so that he doesn't appear to be jumping in on one side or the other. And all of that is to make sure that the people who really matter, the parties in the case, understand they've had a fair hearing.
Well, Judge, I can only applaud that. I think
yes, what is being said here that.
But the legal test is whether there's an appearance of bias, and so it's not just a sort of it's not a fair crack of the whip in the sense
that was a rather loose lay term.
No, I quite understand, Judge. I don't mean to be pedantic, but there's a difference, isn't there? There are degrees, aren't there? So it's, did you get to say everything that you needed to say, as it were? Because clearly, if you haven't, if you've been held out of making your case, if you've been cut off and spoken over, and you haven't made your case, then that has affected the proceedings, hasn't it? That's something that's that conduct has actually had a real effect. So if it's just you come away, the judge put me through the ringer and sort of perhaps as has happened, humiliated me or diminished me or many different things. If it hasn't affected the hearing, though, if it hasn't, I'm not trying to condone this, and I hope that going forward it's a different world. I'm simply saying one has to be realistic, that sometimes in these proceedings you can have the highest standards and try to hold them, but there's a difference between politeness and the conduct in that sense, and whether or not someone's biased, whether or not it's actually going to appear as if they're going to make a different decision, or they're going to stop evidence being put in, or they're going to in some way affect the conduct of the hearing with their approach. And that, in my submission, is what the appearance of bias is about. And it's not to say, as I say, I do in no way diminish the striving for the highest standards of politeness, and hearings are better conducted in that way anyway, because, as I say, that's the most conducive to. But judges do have to control the timing. They do have to, as I say, indicate to advocates if they're going off the rails at times, because that's all part of running a hearing properly. And that's really what the Arab Monetary Fund case is saying, is that that's how, in this jurisdiction, we don't have passive judges who just sit there and then pop out the judgments at the end. We have judges who actually take an active role.
And your case is that that's all this judge did, in a perfectly legitimate way, investigated issues that needed to be investigated, took into account things that were properly taken into account.
My submission is this, that a fair-minded observer would look at the context and would look at why the judge was saying what the judge was saying, the context in which it's saying. They wouldn't sort of have sound bites and take it out of context. And that, as the upper tribunal found, this judge was really concerned that these proceedings would be fair, as it were, and would bring out all the relevant evidence. And that's what he was striving to achieve. And that he wasn't there bullying the advocate, trying to, sort of, as sometimes happens, you know, sort of controlling for the sake of controlling. But what he was trying to do was to say, are you sure about this? Come on, you know, this is really not what's normal. And it's going to lay you open to the adverse inferences. It's going to lay you open to the fact that you will not get evidence put forward before me that might have led me to reach a different decision, as it were. I'm stuck with what's here, and what's here is not as good as this advocate obviously thought it was. This advocate thought he had the winning blow by saying, you're bound by the reasons for refusal letter, and we've got explanations for those, and that's it. And the judge was signalling, I'm not satisfied on that at the moment. You know, I'm going to go away and look at it, but it's not such a clear-cut case to mean that you don't put your best case forward. And in my submission, understood in that light, that is what the frustration is. And maybe it overspills into ways of expressing it that's not ideal. But it must be fair to the judge here. If anyone forensically goes over any transcript, it's always a difficult experience for those who's involved, because it's not an exercise in perfection. I mean, people are doing things all really live, and it really is impossible. It's not a pre-prepared play where everyone can... These are real live reactions, and in my submission, this judge was really concerned. It was genuine concern for the appellant. It was not animosity towards the individual advocates.
Well, thank you. You put that very
So,
clearly and eloquently, and that's really at the heart of
yes, and just
the heart of it. But there are, I know, some other points you want to make.
very quickly, I'll pick them up, my lord, because I didn't see the time. That there's this point about, I just want to deal with these points about the interviews. In my submission,
Points about the interviews.
Remember the interviews? I think visits.
The visits. Yes. Sorry. Yes.
Yes. That it is really important in my submission to understand how they factor or actually don't factor in this appeal. That the submission that was being put forward, that's been put forward this morning about them, is that the significance of these visits is, one, it shows the First Tier Tribunal judge wasn't even-handed because he didn't take an adverse inference from the Secretary of State not putting the records of the...
I think that's slightly overstating it. I think it is simply that he was quite critical, very critical, of Mr. Hussain for producing at the last minute what one rather oddly calls the receipt for the second of the two visits. But one might have thought that he would be equally critical, or at least probing, about why, given that these visits are clearly, one of these visits had clearly taken place, and there was no reason to doubt that the other had, the Home Office hadn't turned up with their own evidence about them. They were on notice that there was that the 2019 visit was going to be relied on because it was in his witness statement. So I think Mr. Jaffergy's point was, why is the judge making such a fuss about Mr. Hussain producing this fairly formal document which shows the visit took place, when the Home Office will actually have notes of the visits themselves, which they never produced?
So firstly, I'm just going to pick up the point without going to it, but I'll ask you to look at it. When you look at why the judge was upset about the evidence being put forward, it was only because they just had a 45-minute adjournment and the evidence could have been produced. And that was the point the judge was making, that we've just had a 45-minute adjournment, you could have produced the evidence then.
Was that when they were reading the determination that they hadn't seen previously?
Yes, my lady, I'm not saying that perhaps... is there an appearance of bias? That's what, actual bias here. And in my submission, what's happening is the judge is a bit cross because they've just got going with the hearing, and suddenly this is produced. And the question
I personally, I see that, and I think in all of us would have been a bit quizzical that it hadn't crossed Mr. Hussain's mind to put this document in. He gave an explanation of why it hadn't occurred to him, and there we are. I wouldn't have made a great fuss about it. But the Mr. Jaffergy's point is more that there doesn't appear to be any criticism of the Home Secretary for not having produced any evidence of these visits.
But, my lord, this comes to the very heart of it. Why would the Secretary of State have an adverse inference drawn against him? And he did use that language, I did write it down. for not putting the materials in, unless there's an allegation of suppressing the materials. That's where adverse inference comes in.
Well, I don't care what Mr.
So
Jafferty said. I didn't actually understand that to be his submission, but this is what's concerning me.
Right. So put that to one side, the adverse inference, because the credibility of the Secretary of State is not an issue in these proceedings. You may dismiss their account, you may
Okay, we got the point.
Yes? So it's not a question of adverse inferences. What the unfairness is said to be, or what's the point of having these interviews in, is that my learned friend says that because the appellant dealt with him in the witness statement, the fact that it's consistent with what the appellant said could help him, and that's without these documents being in, etc., etc., that's not there. But the judge dealt with it by saying, quite rightly, and this cannot be disputed, that all the appellant could say about it was hearsay, because it was just hearsay.
But hearsay evidence is admissible, isn't it?
It is, my lord. But
yeah, from his wife, who was there.
Yes, absolutely. But what does it add in the sense of, if the judge had held it against him, right? If the judge had said, I look at these 2019 visits, I look at this, right? You told me this about it. In fact, it's that. And they were issues that actually were a basis for deciding a credibility point adversely, then they could have some significance in this case, this appearance of bias.
It wasn't the content. I may have misunderstood, but my understanding was that the submission was that it didn't actually matter whether it was visits or what it was. The complaint, as I understand it, is being made, is that yet again Mr. Hussain got into bother with the judge when actually he'd flagged up these visits, had happened in the witness statement, then eventually, probably in an irritating way, produced his receipt. But the Secretary of State, upon whom the burden of proof, I know you don't like the burden of proof, but there is a burden of proof, rests, had seen the witness statement, had seen the reference to the visits, and did not produce the evidence which would have shown the judge one way or other what the position was. And that left a feeling of, well, yet again, they've got at the Mr. Hussain, and the Secretary of State's got off scot-free. That's what I understand it's about.
Dealing with that submission,
I'm not making a submission. I think it's the one that
I thought you were repeating the submission of the appellant.
I think that was it.
So dealing with that understanding of a submission, it would be completely unfair to see it in that way. That the issue was not that it was put in dispute that there were whether or not there were these 2019. So it was a credibility issue for the appellant whether or not there was these 2019 visits and that this was a focus of because this is about whether it was a genuine marriage or not. It's not about.
But Ms. Anderson, the point of the visit, the Secretary of State is worried about whether there's a genuine marriage, despite what Mr. McAckley wrongly says later, sends someone round to investigate whether there's been a genuine marriage on the basis of the registrar's report. That visit is referred to in the witness statement. Anyone preparing a case like that for their Secretary of State would say, we better get out the notes of that visit that's in the witness statement. Now, maybe a mistake was made. The point isn't about, we don't really want to investigate it, and nobody else has. But the point is that the judge didn't seem to be troubled by that at all.
Because it's simply not normal that if something had come out of the visit, right, if there was some issue, right, the visit was non-conclusive, right?
There was a visit. There was something did come out of it. They asked my wife a lot of questions and checked the relationship before giving us permission to marry. Now that clearly is what part of the case against you is. You've checked it all out now, and now you're coming to a different conclusion.
Well, that's the appellant's understanding of
I know,
happened.
but discovery isn't only about putting in the stuff that you think is relevant. You have to put in the stuff that the other side think is relevant.
I understand, Judge, but if that's hearsay evidence of the appellant's understanding of what happened, right? That if someone had said that it's very hard to make this mean anything because really at the end of the day it doesn't actually have any real significance in the overlying. I'm not sure I would accept that it's good practice for because what seems to be envisaged here is either that that there'd be a sort of investigation of this investigation, but the interviewing officers or the visitors, I can't remember which type of immigration officer they are. They would be like policemen. They wouldn't be able to remember particular things and give evidence of it. They would give some sort of They would give some sort of official statement and said, we attended on that day looking at the notes, this, and this. So the idea would be...
There was any suggestion they should be called as a witness. The suggestion was that the notes of the visit should have been made available, which they now have been. And
perhaps that should have been done, but it's not fair to say that it's an uneven-handedness on the part of the First Tier Tribunal judge, because the Secretary of State may produce such materials, may not, as it were. It's not a sort of... unless you're saying a Secretary of State has deliberately suppressed them, which is a different point, and that could be irrelevant.
But nobody was saying that. And although the judge appeared to understand Mr. Hussain as saying that, if you read the transcript, he wasn't saying that.
So if you're not saying that, then it's very unclear in the context of one of these marriage appeals what significance you would ascribe to a Secretary of State not putting it in a bundle. It may not be best practice. It may be something like that, but it's really not a point on which the judge should be criticising the representative if that's what said should have happened, or criticising the Secretary of State if that's what said should happen, because it's just not what's going on in this appeal. Well, it's trying to get to the bottom.
Perhaps we need to move on, and perhaps I've run a red herring here. But the point
simply
was
not normal. It's not.
The point was, though, it left open the possibility, as you say, on credibility, that the appellant was not telling the truth about whether these visits took place, or 2 visits took place, particularly when he only had 1 receipt.
And as I say, the judge didn't take an adverse inference against him on that, so it wasn't a credibility issue. And in my submission, just a last sentence, is that it isn't fair to say that's a basis to find the judge was not even-handed, because that presumes that there should have been a ticking off or something done of the Home Office presenting officer or the Secretary of State, and that isn't the right way of looking at that at all.
Just before... Oh, sorry, I didn't mean to interrupt you.
No, sorry, I'm trying to move on because I'm very...
I know. Just before we leave the visits, we may not think it necessary to deal with this in the end, but I think I take it from what you said, you've got no instructions as to why the notes of the visits weren't available to this to the presenting officer, and you've got no have you got any instructions as to why Mr. McVitie said the visits were unconnected when they clearly were connected?
I'm afraid I've got no instructions.
No, fair enough. Well, we may. It's up to us whether we say anything, but we ought to have given you. If you had an explanation, we'd need to know what it was.
Judge, I just want to make one final point on this because it's in the upper tribunal decision. But the point the upper tribunal judge makes about it, and I think this ties in with the sort of ground 3, or it's actually the second part of this appeal, is that it isn't right to say that this is evidence of an appearance of bias. The part about the visits. So it is my submission, just looking at the clock and being very quick, it's my submission the upper tribunal judge wasn't making findings, but a upper tribunal is perfectly entitled, when looking at error of law, to consider the materiality and the significance of certain matters. And that's not the same as making findings of fact about what did and didn't happen, what was and what. And what the upper tribunal judge says when it looks at this issue is that, this is 63 to 64, it is that the judge puts it in the upper tribunal puts it in the context of this allegation of bias, and says in that context this isn't material, because it's not said it's sort of this is it's my paragraph 22, my skeleton. It's paragraph 52, and then also 32 in the upper tribunal's decision. And so the judge does have a genuine misapprehension of what's happening in the first tier, but it's not the basis for a bias allegation, because the appellant hadn't said that the judge was sort of feigning misunderstanding in order to favour one party over another. This point about the visits in my submission has assumed an enormous significance, which really, when you actually look at the appeal and you look at even the allegations of appearance of bias, it doesn't justify it.
Okay, yeah, we have the point.
It isn't a factual appeal, this appeal, and wasn't in front of the upper tribunal either. It's appeal on a point of law, so it's not an error of fact appeal. And I think that submission might cover quite a lot of my points about the submissions that have been made when going through the First Tier Tribunal decision, because there were quite a few points made which I don't agree with, which are sort of said to be wrong or unfair. So just summing up.
But, yeah, so just before you sum up, what about the judge relying on matters which weren't put?
Well, I mean, does this not completely illustrate the problem? That this is a Maheshwaran problem, that if the judge has concerns about matters and they haven't been canvassed by the appellant and touched on by the appellant, the judge has got a problem. The judge can either raise them in question.
I'm so sorry, we're at cross purposes. I don't mean ones that hadn't been put by the presenting officer, which he then put, but in his eventual decision relying on points that he hadn't put himself, neither he nor the presenting officer had put. I've got a note of what they are, you have as well, no doubt, but we can identify them.
From my memory, Judge, most of those were absolutely obvious points that would come up in one of these appeals. Credibility is an issue, the immigration history is an issue. These are all matters that ought to know, and that's what Maheshwaran says. Maheshwaran says advocates ought to be on notice that in an appeal there are going to be these matters of credibility, and you might choose to say least about it, but it doesn't mean a judge can't then look at it. So you can't constrain the judge by not dealing with matters. So that's the question. Now, if it's a wholly new point, Judge, that no one could have anticipated, then of course I accept that fairness would require, normally, the judge to raise that. But then the judge has got this difficulty of not entering the arena or of appearing. So it's a difficult balance, and what Maheshwaran says is look at each case in its facts and context and see. And that's perhaps a different question to appearance of bias, because that's a question about fair procedure and really whether or not the point's sufficiently important to reopen the appeal. And that's really what the court looks at in Maheshwaran. So sometimes it's such a core issue that it is, you have to do it again, or you have to, because it actually had an effect and it was important, and therefore this was a material unfairness. So in my submission, none of the points raised were. I'm just wrapping up on the sort of final bit.
Of course, yes.
Sorry if I've taken too long. And just to cover the ground, Judge, I think you've got my submissions really on the third point about a structured approach, etc. Perfectly possible to look at all the material and say, is there a material error of law here or an unfairness here? Because it's all part of considering that. Then if you make the decision, of course you're doing proper findings of fact, and you're starting again, and maybe you've retained some findings, but you might have witness evidence, and that is a different exercise. But all the time the courts will look at the materiality of something, and will look at how does it factor. And then my learned friend's skeleton argument, he touched on these final points that were said to be additional unfairnesses, or things that I think you indicated, my lord, that perhaps you're not going into that territory. So I just want to flag up.
Well, which point are we talking about? This is about...
We're talking about these additional points that I think they start, other problems flow. Here we are.
Paragraph number?
I think it's,
the point we really tried to close down was the point about the judge having already been a presenting officer. That's the one I said we won't really get involved in.
Yes, but I think these are matters that, I'll just deal with the submissions, right? That firstly, it's absolutely normal to draw adverse inferences. So insofar as it's been put forward that that's not a normal part of it, you'll see the issue is taken with the upper tribunal saying that's a normal part of the proceedings. So that's contentious because it is a normal part of the proceedings. And the sort of other criticisms of the upper tribunal's approach. In my submission, I'm not sure they make any difference, but for completeness, I'd want to say that all those additional points are contentious ones that I'd ask the court not to look at in terms of what's said. I think it's really 51 onwards. So to sum it all up, it's really anything that's disagreement with the upper tribunal decision that's not central to these sort of points. They are contentious, but I think perhaps we'd all agree that the core issues are the ones that are before the court.
Yes.
And just finally, it is my submission that it does matter that the upper tribunal, as a specialist tribunal, looked at this in the round and is very familiar with these types of hearings. That can only go so far. But where the upper tribunal understands the judge's behaviour in context, hasn't condoned it, the upper tribunal hasn't said this is okay, this is the sort of, but has identified behaviour that's unacceptable in the broader sense. But very carefully shows why it's not fair, and the fair-minded observer wouldn't see this as evidence the appearance of bias, that this judge is going to then behave in a biased way, either in the conduct of the hearing by shutting out evidence, or in the ultimate decision, that will be the basis on which he makes the decision. So unless I can assist further, those are my submissions.
No, thank you very much indeed. Thank you very much indeed, Ms Anderson. Yes.
My
Any
Lord, my lady,
reply, Mr Zafferty?
Yes, I will not go over the submissions I've made this morning, but I just want to focus on some of the points made by my learned friend on behalf of the respondent in relation to the role of the tribunal and the concerns about tying the hands of the judge and some of the references to the cases. In relation to Maheshwaran, this is a relatively old case, which is not to say that it isn't a good case and still applies. In fact, it was considered by the upper tribunal, the Court of Appeal in Abdi, which is in the authorities bundle recently. But it is important to distinguish it on the facts and what it was that the Court of Appeal was considering there. That was a judicial review in the previous system, I think a couple of systems ago, because there have been a number of systems since then, and it was an asylum claim, and therefore the burden of proof was on the appellant. And the issue there, the core issue, was the failure to put an issue to an appellant when he was giving evidence, but in the context of an asylum process where credibility had been raised in the refusal and where the appellant bore the burden of proof. So I just ask the court to take that in mind, bear that in mind when considering the relevance of what is said in that case to the what we would say the very different issues that arise in this case. In relation to the scope of the appeal, and this is something that not necessarily part of the core issues upon which permission to appeal was granted, because permission was granted on the basis that there was an appearance of bias and unfairness. But as the submissions have unfolded, I think from the respondent there's a concern that the court might say something that somehow constrains judges from performing their role properly at the FTT or the upper tribunal. And I wanted to refer the court to some cases which are not in the bundle, which bear on this. And if I could just give the references, they're not cases unconnected with the issues. There's the case of Sadovska, which is a Supreme Court case, which obviously is the leading case on the burden of proof in a marriage of convenience appeal. And there's Sarabjit Singh, which is referred to in the I think the Sheriff Court decision. But one has to look at that in that decision in context when one is looking at the summary.
Well, what do you say we will get? Sorry, is those the two cases, or are there others you want to? You're giving us a list.
Those are the two cases, my lord.
Well, what do you say we get out of those two cases?
What we get out of those two cases in Sarabjit Singh, the context was very different because there was no recording or transcript of what had happened.
Well, hang on. Sorry, I don't want to be difficult, Mr. Jaffe. If you say Sarabjit Singh was completely different, then why are we looking at it?
I think because my little friend took you to the summary of the judgment in the Sheriff Court.
Oh, I see. Okay.
But that summary does not reflect the full context of the proceedings.
Okay.
My Lord Justice Davis, I think, was in that case, and I think gave the judgment. And I just.
I think you've got the wrong Davis, actually.
Yes.
But,
Oh, I see.
Yes.
I mean, I'm always very pleased to be confused with him because all his judgments were quite excellent.
So, in that judgment, I think if I just give you the paragraph numbers so that the context is there.
Okay, give us the full now.
It's paragraphs 42, 44, 45, and 47.
And if we look at those, we will see that if and insofar as there is material which I don't actually remember,
Yes.
from it relied on in Gawley, you will see it doesn't say quite what Gawley might be
Yes, I think the
interpreted
summary.
as saying. It says.
Yes.
I see. Okay.
The difficulty in Sarabjit Singh was that there was a difference of opinion and lack of clarity as to what had actually been said and what had happened.
Okay. It doesn't look to me as though this is something we're likely to have to spend a lot of time on. And what will we get out of Sadowska?
Sadowska, my lord, if I could just refer my lords and my lady to paragraph 28.
And what will we get at is, I just want to know what we're looking at them for before we accept any invitation to look at them.
This is about the framing of the issues before the tribunal and whether it is right that the judge has some sort of inquisitorial
I see. Well, okay, that is potentially relevant. I agree.
And paragraph 28, which is the start of the Supreme Court's analysis, says this in the last few sentences: the respondent is seeking to take away established rights. One of the most basic rules of litigation is that he who asserts must prove. It was not for Mr. Sadowska to establish that the relationship was a genuine and lasting one. It was for the respondent to establish that it was indeed a marriage of convenience. And then at paragraph 34, there is further comment on what sort of things should be taken into account. But it's the framing of the issues. It's for one party to assert and for that party to prove.
Okay.
As far as, again, in terms of what is before the tribunal and what it has to determine, there was a general submission that the tribunal has to get things right. But the ground of appeal that was before the tribunal, I know my lord wanted some sort of clarity on this, and I think perhaps the best way to proceed would be if the parties can agree a joint note on the framework in terms of the way that the right of appeal gets to the tribunal. My lord referred to this morning.
Oh, I see. Yes. Well, I've said a joint note, but it doesn't really matter. I very much doubt if it's going to affect the substance of our consideration.
No.
But in a judgment, you just want to say how it arose. So yes, that's all we need.
Certainly. But the sole ground of appeal is the decision breaches the appellant's rights under the EU treaties in respect of entry or residence in the UK. So again, the ground of appeal is actually focused on the decision. To say without any sort of authority for the respondent to assert that first tier tribunal judges have to get things right and one shouldn't tie their hands is of concern to all appellants and all participants, because one has to have a framework for a hearing. And in a criminal context, in a civil context, the framework is the case that is put by one side and that is responded to by the other side, whether it's pleadings or however the charge is framed. And the authorities that we have in the bundle also show that a general framing of a function of a first tier tribunal judge to just get things right and to just descend into the arena, I think, is the open invitation, so that they pick up on things that one party might have missed, is, in my respectful submission, wrong.
Which cases are you referring us to?
If I could take, my lords and my lady, first of all to Albania, the upper tribunal decision, and that's at page 86 of the authorities bundle.
I think it
Apologies.
is.
No,
I'm out.
195.
it is.
Yeah, 195. I'm grateful, my lord. And in terms of the importance of ensuring that proceedings before the First Tier Tribunal and the Upper Tribunal appear fair, the former president of the Upper Tribunal in this reported decision gives us the second head note, how important it is in today's environment.
Oh, but sorry, I'm sure that's right. But this is only a submission in reply.
Yeah.
What would be relevant would be what I thought you were saying, where that we would find in here some statement like the FTT doesn't have a blank canvas. It was decided cases according to the issues raised. But that's not the point being made in the second head note.
No, it's not the point made. I think that point was premised on a prior submission that it would not be right to tie the hands of First Tier Tribunal judges because of and criticise them or interfere with how they conduct hearings because of the way that these hearings unfold at the First Tier Tribunal.
Well, I dare say, and I know that's what you're getting at, but I just want, if especially in reply, you're going to refer us to authorities, they've got to be authorities that address that question, and so far, Alec Bancroft doesn't seem to be anything to do with that.
I was just going to refer my lord to my lady to the second head note, which shows that.
Well, that's what I've just read.
Assumed, yes, and then paragraphs 6 to 8.
Okay, let's have a quick
in
look.
In terms of the legal principles of fairness, and this is a slightly different, but it's in the same authority, so I thought it's quicker to just refer my lords and my lady to it now. That apparent bias is not some sort of different test unconnected with the fairness of proceedings. It's a principle that is developed from the fundamental proceeding.
Apparent bias is an aspect of fairness. Yep.
Yes. And
I don't think that's probably contentious anyway. Yeah, it's clear from Seraphine.
Yes. And as far as if I could take my lords, as my lord has referred to Seraphine, which is at 43.
Again, page 43.
Page 43 of the bundle.
Yes.
And if I could take my lord to paragraphs 37 to 38 first.
Yes.
And in particular at 38, the extract or the quote from Lord Justice Leggett in Bubbles and Wine Limited.
Yes.
That bias means a prejudice against one party or its case. And so it isn't the appellant's case that there was an appearance of bias against the appellant himself. The appearance of bias, as we've set out in the skeleton argument, seems to unfold from the way in which the case was put, spills over to the representative, and then spills over to the appellant.
Well, but all you need is 39, isn't it? Where he basically says, we've no doubt that the court will be in the presentation correct to treat the claimant's allegation as being that the trial had been unfair, i.e. not based only on bias.
Yes.
And then he says that actually he's not sure what Lord Justice Leggett's definition or is correct anyway. It's rather narrow.
Yes.
So all we need from this, surely, is that, rather as I put to both of you, it's not helpful to look at this in boxes.
My lord, yes, and of course, my lords and my lady will write the judgment, and my lords and my lady might not want to put it in boxes, but because of the way that permission has been granted, it's been argued. Of course, we have to try and put it in some box. But I take what my lord says, and then back to the framing of the issues before the tribunal. Paragraph 42, and this is in my submission important. because if it is being said that the usual way that a case and a hearing unfolds in adversarial proceedings ought not to apply to the First Tier Tribunal, it is difficult to see how one gets away from the core principle in an adversarial system that the judge doesn't enter into the fray and start looking at whatever the judge thinks is relevant, even if that has not been raised by a party. One has to apply one's mind as a judge and judgment to a case based on the framing of the issues by the parties. And that's the fundamental principle of the adversarial system, which is what we have at the First Tier Tribunal. If I could then take my lords and my lady to TUI, and paragraph 42, and I'll give you the...
Well, first of all, give us the page.
Yes, it's page... Sorry, it's paragraph 41, page 30 of the authorities bundle.
Well, again, this was a case that very different issues arose.
Yes, it's the principle of the adversarial system, my lord, that I wanted to take you to, and it's 41, and it sets out in an adversarial system subject to the constraints of case management. The parties frame the issues which the court is to determine. It is not normally part of the court's business to investigate admitted facts. Trial judge's role is normally limited to determining the disputed issues.
Yeah. Okay, well. Anything else?
And if I could then finally take you to Abdi, which is a recent case of the Court of Appeal, and it's page, I believe, 86.
No, wrong again. 73. That's the start of it.
Yeah, that's the start, my lord. I was taking you right to the paragraph that I wanted you to look at. Apologies. And it's the postscript.
Whose judgment is this?
This is...
All right, thank you, yes. Lord Justice Popplewell, yeah?
Yeah. And the two things that the judgment, by way of postscripts, makes clear: I'm not expressing any view as to whether it formed a proper part of the FTT judge's role in adversarial proceedings to take the point which formed the basis for her decision when that point had not been taken by the respondent. So that is an issue that's flagged up as one that's not being determined, but perhaps it does fall for determination in this appeal on the basis of the way that the respondent puts his case. And I think the second point as well, it isn't the appellant's case that this appeal should result in far-reaching consequences on the way that judges approach hearings at the FTT. No doubt there will be guidance, and no doubt that guidance will and should be taken into account, but the appellant is not asking for some explosion of advice from the Court of Appeal that is suddenly going to result in turmoil at the First Tier Tribunal or the Upper Tribunal. The Upper Tribunal itself has repeatedly reported cases that tells judges how they should conduct hearings, where the line is to be drawn, and the Court of Appeal is likewise simply, if it does, providing guidance based on the facts of the appeal before it. And Abdi is a case, I think it's from this year, last year, sorry, where again the Court of Appeal had to say that the conduct of the hearing was unfair, and if it is unfair, it is unfair.
Yeah.
There is nothing that should stop the court from saying so.
Well, my lady remembers all about it.
And I think the final thing...
So it was so recent.
We're getting to your second final point.
This is the final point, and I don't want to take my lords and my lady to the case, but just as a matter of interest, the case of Argo, which was the case that was cited for all the relevant principles, in that case the strategy adopted at the First Tier Tribunal was not to call the EU national spouse. So it's not something that
I'd
is
forgotten that.
unusual or unique, or something that should have been entirely
Well, I think there may have been a suspicion, it wasn't quite like this, there may have been a suspicion that he wasn't willing to... no, hang on, that's not really a very good point, because I do remember this, but I go, the marriage had broken up. I agree, in theory, the ex-wife might be willing to help her ex-husband, but there were some pretty obvious reasons why she may not.
I don't think Argo is that case, my lord. But my lord will correct me.
We'll have a look.
Yes,
we'll have a look, but it's not going to go to the heart of the case.
No. I'm very grateful, my lords and my lady.
Thank you. Thank you to both advocates, and we will be reserving our decision. Judgments will be circulated in draft in the usual way, for the usual limited purposes, which I won't remind you of, but if you need any reminding, you can look at the Counsel General for Wales case, which also is relevant to who they can be circulated to. And we will obviously therefore deal with consequential matters in response to the submissions that the parties make following circulation of the judgments in draft. Thank you.
Court is available. It's going to be an interesting judgment.